Okay, in today's video I want to take a look at wills in special cases. What are special cases, I hear you ask? Special cases are essentially where the person making the will, the testator, is in danger of imminent death or is an elderly testator. Imminent death may cover somebody, for example, who has a terminal illness, maybe in a nursing home. Elderly testators, obviously, that speaks for itself. The potential issues that will arise in these categories will be to do with undue influence and testamentary capacity. Undue influence obviously is where somebody is vulnerable and dependent upon somebody else and may be susceptible to being influenced as to their will and as to what they're putting in the will. Testamentary capacity arises obviously in relation to an elderly person or indeed somebody who may have a terminal illness and may be taking a lot of drugs, taking a lot of medication, and may not just quite understand what's going on. So testamentary capacity goes to whether the person knows what they're doing and what's involved in making a will. What is the impact and the effect essentially of what they're doing. Imminent death is a testator in hospital or a nursing home. The testator must be capable of making a will. That is, they must understand what's happening. A medical report on the testator may need to be obtained to verify that he or she was capable of making a will and knew what was going on. You will need two independent witnesses as usual. This can sometimes cause a problem in a nursing home or a hospital because sometimes medical personnel, care staff don't necessarily want to get involved with a will just in case there's a dispute afterwards and they don't want to be involved. I've just had that experience, unfortunately, so you do need to be careful that you have two independent witnesses if you're making a will with somebody in a nursing home or a hospital. Elderly testators then can be vulnerable due to advanced age, lack of education, mental incapacity or ill health. Nevertheless, in Irish law there is a presumption of testamentary capacity, soundness of mind and due execution of the will. Testamentary capacity then looks at a number of issues, and it goes back to a case from 1870 involving Banks v. Goodfellow. One, the testator must understand he's making a will which will dispose of his assets when he dies, when he passes away. Two, the testator must be capable of knowing the extent of his estate. In other words, he must know what his assets and liabilities are. And number three, the testator must be able to give consideration to those people who might expect to benefit and decide whether or not to benefit them. Ultimately, it's his decision, but he must be able to give consideration to those people. Undue influence then is something that can arise in relation to elderly people. There is a situation of presumed undue influence in certain relationships, for example, solicitor-client, doctor-patient. It is presumed that a solicitor or a doctor will have a fair degree of influence over a patient or a client. Other relationships can arise where the testator places trust and confidence in the other party. Independent legal advice for the testator is the recognised way of rebutting any presumption of undue influence. In other words, if there's going to be a dispute later on saying that such and such a person was making that will under undue influence, then independent legal advice having been obtained and a solicitor swearing that they were happy and satisfied that the person knew what they were doing and they weren't under any undue influence, that's the best way of rebutting any presumption of undue influence. My name is Gorry. My contact details are on the screen. I hope you find this video useful. If you do, you might give it a thumbs up down below, and you may be interested in subscribing to my YouTube channel. My YouTube channel deals with all aspects of Irish law and Irish business, and I try to explain Irish law aspects of it in plain English, plain language. Thanks for watching.